That being said, I'd like to introduce John T. Griffin. He is board certified by the Florida Bar as an expert in elder law. Mr. Griffin is a partner in the law firm of Griffin and Griffin. He practices in the areas of elder law, estate planning, VA benefits, Medicaid planning, asset protection, probate, trust administration, and special needs planning. Mr. Griffin is licensed to practice law in Florida. His professional associations include the National Academy of Elder Law Attorneys, the Association of Florida Elder Law Attorneys, the Florida Bar Elder Law Section, and the Sarasota County Bar Association. Mr. Griffin has served 2 terms as chairman of the Nursing Home Residents' Rights Special Committee for the Elder Law Section of the Florida Bar. He served as the 2010 co-chair of the Florida Bar Elder Law Section Public Benefits Seminar, and he's also served as an Academy of Florida Elder Law Attorneys area representative for the Sarasota region, and as the 2007 to 2008 chairman of the Sarasota County Bar Guardianship Subcommittee. He's a very busy man. We are so honored to have you with us today.
Thank you, Diane. I
Thank
appreciate it.
you, and I'm going to go ahead and turn it over to you.
All right. Thank you so much. Well, nice to see everyone's faces out there. Thank you for joining in today. Feel very lucky to have NeuroChallenge in our community serving such an important role. So thank you, Diane, for all you do. And thank you, everyone, for checking in. I see a few familiar names amongst the viewers. So good to see all those who I already know and all the new faces as well. So today they asked me to talk a little bit about sort of being prepared for this next stage of life, right? We've got, I call it solving the puzzle of long-term care. So we're going to be looking a little bit about, what kind of care is available? What are the costs of those levels of care that we might need as we age? What are some of the pros and cons of different options? And probably importantly, how do we pay for those, given the rising costs of all of that care? And then finally, we're going to talk a little bit about the estate planning things you should be doing now to be prepared for those levels of care when the time comes. So I think we're going to do this, as I understand, Diane, right? We're doing it as an open format. So if you have questions while we're going along, simply unmute your microphone and chime in, and I'm happy to answer anything as we go, okay? So I don't have available in my view, the way I have it set up, because I have the presentation, any questions in the chat. So if anybody would prefer to chat questions, maybe if somebody else is looking at the chat, they can let me know that there's a question there as well.
Absolutely.
All right. Thank you, Diane. Okay. So first, let's just look a little bit about the scary numbers that we face as we get older. This particular slide deals mostly with Alzheimer's, but of course, this group may know more than others that, Alzheimer's is only one of the many conditions we might be facing as we get older. It would include Parkinson's and all sorts of things that might limit our either physical or cognitive abilities as we age. So here in Sarasota County, just looking at Alzheimer's, they've already indicate that 1 in 7 people have already been diagnosed with Alzheimer's. So very high statistics here locally. Of course, we all know that's because we're a more senior community than many. But the odds of us developing dementia by the time we're 85 are 50-50. So that's 1 in 2 people are going to develop some form of dementia by the time they're 85. When we compare that to a house fire, you have less than 1% chance that your house will ever be damaged in a fire. And yet almost everyone carries homeowners insurance, right? But very few people carry the proper protections for aging and these issues. So when we look at the statistics, in some respects, we're preparing for the wrong things. And so we're going to talk a little bit today about what we can do to help with that. So I like to call this a team approach. We've got, while we will handle some aspects of this as an elder law attorney, you've got to look at what your support network is. Your family and friends, obviously, being one of those keys to providing care, to making sure you're taken care of. Having an attorney, having a financial advisor. I was talking to someone today and looking at the changing needs. Her husband just died in March, and he handled all the finances, but he invested things himself. They were in a self-directed IRA. And now that he's gone, she doesn't know what to do, where to start, but she's a little bit frozen. And so we're trying to talk to her. Well, maybe if you don't know anything about finances, you don't want to be self-directing your own management. So bringing in a financial advisor can be important. Your certified public accountant or your tax preparer, and then an insurance agent looking at what you should and shouldn't have at that age. Sort of a whole team is required. And of course, I would add in, that's not on this slide, groups like NeuroChallenge that can provide support, guidance, and direction when you get that diagnosis and don't know where to turn. Someone like Diane stepping in and being able to help is a huge benefit. So luckily, we live in this area where we have a lot of services, right? There's many parts of the country where you can't get help when you need it. But, with our aged population, we're in good shape here. So then let's look at a little bit about our housing choices. There are 3 listed here. This can really be broken down into 4, a little bit further into 4, which is the first option, and the one that most people choose at first is, staying at home. Most people say, I want to stay at home. If I can't stay at home, I don't want to go anywhere else. The problem with staying at home can be that you need to have a caregiver a lot of the times. Now, I don't know how many folks in the group are already dealing with either Parkinson's themselves or a loved one who's been diagnosed with Parkinson's. I'm assuming it's a high percentage of the viewers here are at least have it active in their life. And one of the things that we have to weigh when we look at that is, what does that mean emotionally for the caregiver, right? It's the Alzheimer's Association uses a statistic that I think something like 63% of caregivers fail to survive the people they're caring for because of stress, right? The stress of a caregiver can be extremely high. And so when we look at staying at home, even though it's often the preference, we have to weigh that against the real risk to the people that we're relying on to provide the care. If we have to bring in outside help to cover some of that care or all of it, staying at home can actually be one of the most expensive options. The rough estimates there is about $30 to $35 an hour right now for unskilled non-nursing care at home, which at a 24/7 pay schedule can be more than $25,000 a month, which then of course is almost $300,000 a year to try to stay home with 24/7 care, which is really, unaffordable for most people nowadays. It is also the level of care for which there is often the least amount of help from a financial perspective. The government does offer a small program to provide some in-home care, usually around 10 to 15 hours a week. But most of that, if you need in-home care, most of that you're going to be paying for yourself. There is also some VA benefit that we can get, which we'll talk about a little bit further. But for the most part, living at home is the most expensive option and the biggest risk to the care recipient, because if something happens to the caregiver, there may be no backup in a home setting. So it can be very, very challenging. Next level of care that we would look at is the assisted living level. Now, this is the area where we can really break this down into 2 separate pieces. The first is the assisted living facility, what would be traditional, sort of your own little apartment. You may receive some care. They're usually going to provide meals for you. They are going to provide some access to nursing, usually several times throughout the day if you need it. They might provide medication management. A lot of those services are provided a la carte. So if you need bathing assistance, you pay for that. If you need showering, if you need dressing assistance, you pay for that. In an assisted living facility, what you're looking at typically is needing to be at least somewhat independent. You need to be able to stay in a room by yourself, managing what we often refer to as your activities of daily living, dressing, bathing, toileting, personal hygiene, up and down out of a chair or bed, walking. Once you are not able to get out of a bed or chair or toilet or are wheelchair dependent, often you are no longer eligible from a level of care perspective for the assisted living setting. Now, recently, or since I've been practicing, which now is 21 years, when I started practicing, there weren't really something called memory care. That was not really something that existed in any large numbers, at least here locally. Since then, it feels like there's a memory care unit on every other corner as you drive around town. So there's a lot more of them than existed when I started practicing. And the big difference between a traditional assisted living and what they commonly refer to as memory care is that it's going to be a locked facility, right? So if your loved one is a flight risk or exit seeking or needs more one-on-one care, then that memory care facility can be a good option. The issue with that is in a traditional assisted living setting, you're looking at prices that range at the very low end of around $2,500 a month to $5,500 a month for that level of care. If you bump that up to memory care, you're typically looking at a cost of $4,500 a month, all the way up to around $7,500 a month for memory care. And so, again, that's can be cost prohibitive for folks, either with limited resources, fixed income, or without long-term care insurance. Those costs can be very burdensome. When we compare assisted living to skilled nursing setting, what I like to say the big difference is when you walk down an assisted living facility hallway, it feels a lot like your own apartment building. All the doors are closed. You have staff working there, but they're only going to come in and check on you, knock on the door, and see if you need assistance. In a skilled nursing facility, that's going to be more like a hospital setting where every door is open, right? When you walk down the hallway, people should be walking in and out of the room throughout the day, checking on your welfare and well-being, seeing if you need assistance. And so if your loved one is not going to be independent in a room by themselves, then assisted living is probably not appropriate. When we look at the cost of a skilled nursing facility, though, average cost of a skilled nursing is between $10,000 and $15,000 a month right now in Sarasota. There are facilities that cost more than that. For average, you're probably looking around $12,000 a month. And so even at that level of care, you're looking at $140,000 a year or so. And so again, can be very cost prohibitive. The good news about that skilled nursing home level of care is that we can potentially get Medicaid to help cover that. And so Medicaid is a scary word for a lot of people because when we often think about Medicaid, we think about the programs you hear about on the nightly news, often for low income, low asset individuals, unwed mothers, children. You hear Medicaid thrown around a lot to cover a lot of different groups and programs. But the reality is that this particular program, what's called institutional care Medicaid, is probably one of the most generous government benefits that exists. For some folks, it means that the government will pick up 100% of the cost of that long-term care. So there are very often scenarios where a husband and wife, once we do the proper planning and get them on Medicaid benefits, they're paying little to nothing of that nursing home cost every month, a benefit that's protecting or saving them, $140,000 a year. So we'll talk more about that Medicaid program, but obviously a huge benefit. And it happens to be that here in Florida, we have one of the most generous Medicaid programs in the country. So as far as planning for our individuals and our families that we work with, we can often protect and preserve a lot of the resources that you have available. Any questions about those levels of care? No? Okay. So I like to joke that there's a fourth option, cruise option, right? Average cost of care, according to one website, is about $3,000 per month per person if you were to go on a budget cruise line out through the Caribbean. And so that's cheaper than a lot of assisted living facilities run. And you can have a lobster night, steak night, shows on board. There's a casino, a doctor, basically everything you need right there on the cruise ship. For those of you that like to do that, you can certainly consider that option as well. So how do we pay for all of this level of cares, right? One thing that probably most folks on this call have is Medicare, right? So does Medicare cover any of those long-term care costs? And the answer is generally no. Medicare is just health insurance. It was a replacement for maybe that Blue Cross Blue Shield policy you had when you were working. They cover acute care, which means I'm injured, I'm sick, I'm hospitalized. I have an immediate need for medical attention. Medicare is going to cover that. What you may also know is that Medicare can cover some rehabilitation. So if I fall and break my hip and I need to get, therapy, rehabilitation, Medicare will pick up some of those costs. Typically, Medicare covers the first 20 days at 100%, then the next 80 days at 80%. So a total of 100 days potential coverage for rehabilitation. So I break a hip, I'm not walking, I go into a rehab facility, 20 days I'm covered, 80 days I'm at 80%. If I have a traditional Medicare supplement on top of that, so maybe I have the AARP or United Healthcare supplement, that covers the other 20% of those 80 days. So with a traditional Medicare supplement and Medicare, they're going to cover 100 days, up to 100 days of rehabilitation. Once those 100 days are up and I become a long-term care resident at a facility, then it switches to private pay. One of the things we need to be concerned about when we talk about that rehabilitation benefit is that a Medicare supplement, if you have switched to an HMO style supplement, like a Medicare Advantage plan, you may have given up some of that benefit. So when you switch to a Medicare Advantage, you often give up that protection. On that protection, the average cost of a rehab day of that 20% that's not covered by Medicare is somewhere around, I think right now, $197 a day. So let's just round that up to $200 a day times 80 days. That's a $16,000 out-of-pocket cost for that rehab if you have switched to a Medicare Advantage plan. And a Medicare Advantage plan, often the enticement for the folks who switch is maybe you pay lower premiums. Maybe they offer you a free gym membership or free eyeglasses or something to entice you to switch from traditional Medicare supplement to Medicare Advantage. But all of that savings that you may have gotten will be wiped away in a single medical event if you need rehab. So it's really important that if you have switched to a Medicare Advantage plan, you understand if you've given up that rehabilitation benefit, because a broken hip, broken shoulder, knee replacement, anything that causes you to need rehabilitation, you may have given up a huge benefit, and that can be a costly mistake. So if you met somebody and they convince you to switch to a Medicare Advantage plan, be sure that you're evaluating that program and meets your needs. I like to say that, Medicare Advantage plan is great insurance for people who are healthy, but that's not what we buy health insurance for. We buy it for when we're sick. So be sure to make sure you understand your coverage. But no, Medicare doesn't cover any long-term care needs. So it is important for you to understand that all of those expenses are typically out of pocket after that rehabilitation. Any questions about that? No? Okay. Remember, anyone can chime in at any time. So how do we pay for that care? Option number one in paying for that care is the good old-fashioned pay out of pocket, right? Every place in town will take your cash and be happy to charge you full price for any of these services. When we look at income sources, we're going to look at Social Security, pensions, IRA distributions, investments, annuities, anything that you have, they will, be able to tap into. One of the things that we want to be concerned about when we look at paying for these things privately is you may look at your income right now and say, okay, well, I make this much from Social Security, I get this much from a pension, and my investments generate this much income. So I'm able to afford, I think, this care for a long time. But one of the things we have to be concerned about is as you spend that principal, right? So if you had $200,000 generating income, but you have to spend some of that $200,000 on care, you're going to lose the income associated with those assets. So sometimes the drop off in costs is not slow and steady, but sharp decline, right? Because I'm losing income, which means I have to spend more principal, which means I get less income, having to spend more principal, less income, and it unfortunately is a self-perpetuating problem. So you can end up finding that that money does not last as long as you had hoped it would as you start spending those assets down. So also we look at, what assets are available. In Florida, for the most part, you're going to count everything that you own: IRAs, annuities, jewelry, art, life insurance, cash, CDs. Anything you own is accessible when looking at the costs of long-term care. So we just want to be conscious of the fact that, in your net worth, you may be including the value of your house, but that house equity may or may not be available to you to help you assist in covering these costs of care. So you just want to really be evaluating your ability to pay for these things. Next option that's available is long-term care insurance. So those of you that may have long-term care insurance, the important question for you is, how much coverage do I have, right? Long-term care insurance has um, no common factors from policy to policy, right? So some people come in and say, I have long-term care insurance, and that coverage is $80 a day for 2 years. Some people come in and they have $350 a day of long-term care insurance for a lifetime, right? So just having long-term care insurance isn't enough to tell you whether or not you're prepared to cover these costs. Obviously $85 a day is good, but it's only going to pay for about 2 hours of in-home care, right? It's not going to pay the cost of a nursing home. It's not really going to cover the costs of an assisted living facility. And so you just need to know what the amount of coverage you have. The other issue that often is looked at is how long will I be covered, right? The original policies, you see them all over the place. Some were 2 years, some are 3 years, some are 5 years. Those are common lengths. And then the sort of Cadillac is, some people have coverage for life, so they don't ever have to worry about the costs if they have enough daily coverage. If your policy is fixed in time, usually that means that you have a gross amount of money that you can use, right? So if I have $100 a day for 3 years, let's just run that number there. If I have $100 a day, that's times 365 days in a year, times 3 years, that gives me $110,000 of long-term care insurance benefit. So if I'm only using $50 a day, I might be able to stretch that 3-year policy out to 6 years. So often it's not, I only get 3 years. It's, I get only a certain number of dollars a day. And if I use less than that, I can stretch that money out. So for those of you that may have higher policy limits, but lower needs, you might get more than the amount of time you originally thought you contracted for and can stretch out that care. The other suggestion I make for folks who have long-term care insurance is start using the benefit, at least at a low level, as soon as you're able to, right? Once you meet what we call the level of care for your policy. Because often, and you'll have to check with your own insurance company what you have as far as coverage, but often they have what they call a waiver of premium rider, which means once you need it, you get to stop paying for it. So if I start even an hour a day of services and I'm paying $5,000 or $6,000 a year for that long-term care insurance, or maybe 3 or whatever it is, once I start using it, I don't have to keep paying for it. So a lot of times you don't want to wait until the very last minute thinking you're going to save it all for the nursing home, right? Do it while you can. Use the benefit. The last thing you want to do is die with insurance money unspent, because that means the insurance company wins, right? So the other difficult part with long-term care insurance, like most insurance, is they are in the business of not paying benefits, right? They are going to make your claim a difficult process for the most part. And so the sooner you can start that process, the sooner you can start getting those benefits. Sometimes you have to work with folks to make them pay, right? Because they don't want to pay. They say, well, you're not sick enough. You don't meet the criteria. You don't have the right level of care or the right person in there. So you don't want to do it when you have a strong need. You don't want to be under those pressures to be negotiating with the insurance company for coverage. So start early and start using it is typically my advice. The other thing I'm going to suggest for everyone who has it is to contact your long-term care insurance company if you haven't already done so, and add a secondary person as a contact person on your policy. Every insurance company has to take a secondary contact. So let's just say, for example, your child, right? Someone who doesn't live in your home typically is who you want. Because if you develop, let's say, dementia, and you have this long-term care insurance, they would love for you to forget to make a payment before you claim this benefit, right? Because if you forget to make a payment, they get to cancel your policy right when you need it. And so by going on and naming a secondary person, that person will get a letter before they cancel your insurance to say, hey, dad didn't pay this bill, and in 30 days, we're going to end this long-term care insurance. And then your child can call you and say, hey, dad, they said you didn't pay your bill. Let's go on and pay that now so we don't lose this coverage. But I can't tell you, unfortunately, how many folks don't do that. And the children come into me and say, well, dad had a policy, but it lapsed last year because he didn't remember to pay the bill. So definitely add someone on if you've got that long-term care. If you don't yet have it, long-term care insurance is like any other insurance. They won't insure your home while the hurricane's coming, right? They won't insure your home while the kitchen's on fire. And they will not insure you for long-term care once you've got anything wrong with you. So one of the tricks of long-term care insurance is getting it early enough to beat the doctor to the diagnosis, right? So my wife and I, of course, we do this every day, and we see that you don't have to be 75 to need long-term care. We've had our insurance in place since we were in our 30s. And so that if we get diabetes, heart disease, lung issues, we're already insured. Once they think you are going to use this, they will not give it to you. So my suggestion is you plan early. There are some long-term care insurance that are more generous with health needs. There are now some policies that you can buy through an IRA, which is often a good place to do it, because what they do for those policies is they will, and I don't sell long-term care insurance. This isn't a sales meeting. I just want you to understand your options just so no one tunes out thinking I'm trying to sell you something. They have these policies now that you can use IRA money to buy long-term care, and you pay up in advance. So I might pay $100,000 of IRA money for a $300,000 long-term care. And I'm just making those numbers up for discussion, right? I can leverage my IRA money that I'm not potentially using right now on long-term care. And then if I draw out those benefits under a long-term care policy, I don't pay the income tax on it. So I get a tax-free benefit because I didn't pay tax when the money went in, and then I don't pay tax when the money comes out. So that can be a great option for some folks. The other thing is a lot of times they have policies that are sort of use it or don't lose it, right? My type of long-term care that I have, if I don't use it, I die. My premiums just belong to the company.
Hello? Not sure what happened. He's frozen.
Yeah, he's frozen.
Yeah, he froze, so we're gonna hope that he pops back through. I'm messaging him.
Thank you.
Okay, sorry about that. With all this weather, I think we're having some internet outages here. So bear with me if we come back in. So I think I was saying just plan early with long-term care insurance and have that get it while you can. Any questions about the long-term care insurance? No. Okay. The one other thing I guess I'll mention is some of you may have what we call a partnership plan, which is a type of long-term care insurance policy that if you use the benefits and it has certain features, the government was trying to encourage folks to do this type of insurance. So they are, I've got to hang up the phone. I'm sorry. It's talking in the background. So I'm going to disconnect that one. That encourages you to get long-term care insurance because what they're going to do is every dollar that you spend on long-term care insurance, they add that dollar to the amount of money you can keep if you ever need Medicaid. So let's just say, for example, if I'm an individual and I have a $2,000 asset limit for Medicaid, but I have already used my long-term care insurance with the right partnership benefits of $100,000. When I need Medicaid, I actually get to keep $102,000 of assets. So they let you apply all that money you used by being insured to keep it for yourself and your kids. So that can be a huge benefit for those of you that have a partnership policy. To be honest, we haven't seen a lot of those in action yet because they were sort of implemented in 2005. And a lot of the folks that were getting long-term care insurance in 2005 aren't yet needing long-term care. So I think we're going to see more of this coming up in the future, but it is a huge benefit if you do have long-term care. Now let's go back here. Okay. So next up then would be VA benefits. VA benefits are great tax-free cash benefits for the most part to provide services for you, whether you're at home or in an assisted living facility. Those are the typical ones that we're looking at, what we call aid and attendance. There are many, many VA benefits, so I'm only going to talk about two really here. The first one being aid and attendance. That is, in order to qualify for those, you or your spouse, your last spouse, has to have served been discharged other than dishonorably. You have to have served at least 1 day during a period of war, which is, obviously World War II, Korea, Vietnam, Gulf War. Any 1 day is fine. And you have to have certain asset criteria. As a general rule for the VA, you have to have $155,000 or less to qualify for this aid and attendance benefit. That 155 usually excludes your primary residence, but it does include the value of almost everything else that you own. When we look at the time of service, you want to look at your DD-214 and make sure that your dates of service line up with the government's dates of service, because when the war was going on may be different than when you think the war was going on. So for example, every soldier who has served from the early 90s, right, first Gulf War to today, we have been in a constant state of declared war for the last 25, 30 years. So every veteran qualifies. My son, actually, we just took him off to boot camp yesterday. And so he has served his first day today. There is a war in the world today. And so he will be, no matter what happens going forward, a wartime veteran. You do not have to have served in an active duty combat area. You could have been peeling potatoes in the Tampa Bay and still qualify, so long as you served during a time when you could have been called to war. I get the question a lot, what about reserves? Reservists have to have been called up to active duty in order to meet that wartime day of wartime service. So just know that those are the basic benefits. Now, when we look at the sort of Cadillac of aid and attendance, I'm going to talk primarily about that. The monthly benefit that you might qualify for as a single veteran is about $2,300 a month. That goes up to $2,700 if you're two vets that are married. and about $1,478, so just shy of $1,500 if you're the surviving spouse of a wartime veteran. And that is the last spouse of a wartime veteran, right? So if you've been divorced and remarried, it has to be the last spouse who qualifies. That money, like I said, comes to you tax-free once you meet the level of care criteria and asset criteria. Although this particular benefit works in a little tricky way to calculate what you'll get. So if we were to look at someone who makes $1,500 a month in Social Security and is in an assisted living facility for $3,000 a month, let's just say, for example, this is the widow of a veteran. That widow would get $1,478 a month in benefits. So he or she would have their $1,500, get the $1,478, bringing them pretty close to the $3,000 a month they would need to cover maybe a low cost assisted living. If, however, that same widow made $3,000 a month in monthly income and had a $3,500 a month assisted living bill, they would only get the $500 difference from the VA to cover their needs, right? They're not going to make the extra money necessarily it's not an income program in that way. It's really designed to offset your costs. So it's a little tricky how that works. I don't actually even, I might have just calculated that wrong, but the most important thing is you probably need to sit down with someone with your income. I was doing this on the fly, your income, look at your costs. We'll be able to calculate at that time what the VA would likely give you in any 1 month situation. So you have to basically be spending all of your money on medical expenses in order to get the maximum benefit. So if you're getting, in that scenario before where I calculated wrong, is if you're getting $3,000 and you spend $3,500, you would get the full benefit. If you make $3,000 and spend $2,500, you will not get the full benefit. Your benefit will be reduced by your excess income. So I reversed that a little bit the way I wanted to tell you that. But just know that it's probably important to sit down with someone if you qualify for these benefits with your income and assets in front of you, and we can help you understand what benefits you might be entitled to under the aid and attendance. Okay. And again, remember, you do not have to have served overseas. You just have to have had a day of wartime service. Questions about the VA benefit yet? No? Okay. Just the last thing that I want to talk about with the VA is two things. One is what medical criteria they look at. The first is you need the assistance of another person to live safely in your setting. So this aid and attendance benefit is usually not used to cover nursing home care. I'll talk about that in a minute. This is typically used for home or assisted living levels of care. You have to be unsafe. You have to need the assistance of another person. Now, that may also include for VA things like queuing, right? So when I talk to my families about medical need, often I say, well, tell me about your loved one. What can they and can't they do on their own? Well, they're pretty good. I hear all the time. They're pretty good. Yeah, I mean, they're fine. So then I say, well, let me ask it this way. What if you weren't there for 3 days? What would that look like? Oh, I have no idea. Would never leave them alone for 3 days, right? So sometimes when we start looking at this, if they can't be left alone, if they wouldn't dress, if they don't know yesterday's clothes from today's clothes, if they don't, with Parkinson's, if they can't put on shoes or unlock a door or don't know expired milk from unexpired milk or expired meat from unexpired meat, if another person has to be there, if someone has to tell you to bathe, right? A lot of times with dementia, bathing is the first thing to go. For whatever reason, it just isn't something a lot of people want to do once they have dementia. And so if you have to be there saying it's time to bathe, come on, well, I bathed yesterday. No, you didn't. It's been 3 days. Let's go. Or if you even if they'll go in and bathe, but don't use soap, don't use shampoo, conditioner, whatever it is, all of those things might qualify medically for VA assistance. They're much more liberal than Medicaid is for that benefit. So again, you want to start this benefit as early as possible if you think you meet that medical criteria. Now, for skilled nursing home care, know that for the VA, They also do provide some assistance to some veterans in a skilled nursing home setting. Really, where we look at the best benefit there is if you are 70% or more disabled, you may qualify for 100% nursing home coverage in a Medicaid, a VA accepting nursing home. So for disabled veterans, that benefit can be huge, including 100% coverage in a VA accepting facility. So if your loved one is not already going to the VA and they qualify for VA benefits, you want to have those medical evaluations. You want to see what they might qualify for, because if you can get them VA disabled, not only are you going to be getting extra income now, potentially extra income if they need aid and attendance, but also that potentially that very high benefit of getting full nursing home coverage. So take them to the VA, make those annual medical appointments, tell them if something has changed or something has gone wrong, and really use those benefits. Don't leave them on the table. Even if 10 years ago you went and they said you don't qualify, go back, check again. That's your right, and see what benefits might be available to you. In Sarasota County, and Manatee County for that matter, Charlotte County, really every county right now locally has a VA service office, which are individuals that work for the county that will help you understand your benefits and what you might be eligible for. So if you think you're eligible, a great first stop is to go online, make an appointment, or call them, make an appointment with the local VA service office, and they will help walk you through some of this process and see what benefits you might be entitled to. Okay. Any questions about VA? No? Great. All right. So next up is Medicaid. And Medicaid is sort of the Cadillac of government benefits. Because as I mentioned earlier, it might cover that full $10,000 to $15,000 a month nursing home bill that you might be facing if your loved one needs that level of care. When we look at Medicaid, and they're going to evaluate each candidate on three criteria. They're going to look at health, they're going to look at income, and they're going to look at assets. And I'm going to go forward a little bit to another slide that talks about what happens if you're married. But as a general rule, this applies to the applicant, the person who's in the nursing home. You need to have more or less hands-on level of care, right? It's unlike the VA where they say queuing is enough, right? Hey, it's time to shower. For Medicaid, they're going to be looking for someone to have to be there to say, get the correct temperature, dump the shampoo into your hand, make sure you're toileting properly, make sure you're physically able to put your clothes on, take your clothes off, wash your clothes, maybe make the meal for you, right? They're going to want someone who's got to be hands-on providing care. When you talk to the doctors about getting that classification, again, I always tell my families, you want to be talking about the worst moments of your worst days, right? If my wife is good 4 days a week and can't get out of the chair 3 days a week, then she can't get out of a chair, right? Because if I have a heart attack and I'm dead on the floor and she can't get out of a chair for 3 days, she's also dead in a chair, right? So we want to look at those worst moments, worst days, and say, hey, you may be able to do this 80% of the time, but the 20% of the time you can't, put you at serious risk. And so always be, as much as you love the person you're caring for, you always want to be talking about this in sort of the worst light. So you're sure you're getting all the benefits you can under those circumstances. So many spouses, I'm going to look at you wives in particular, want to talk so positively about the loved one and the sort of minimize the care that you're providing, but you don't want to do that when we're talking about benefits, because it can hurt what you're eligible for. Okay. Income wise, Florida, this is one area in which Florida is trickier than other places, because in Florida, we have an income cap. Now, not all states have an income cap, meaning for applicants that are applying for Medicaid, you have to have less than $2,839 a month. If you have $2,839 a month or more in income, in Florida, you have to jump through a special hoop called a qualified income trust. And that qualified income trust is a type of trust that is going to basically every month you're going to move income from your account into a new checking account called a qualified income trust. So I like to call it government ordered money laundering, right? So what they're saying is if you make more, let's say you make $3,000 a month, you make too much money to get Medicaid, but you're about $8,000 or $9,000 too short to pay for the nursing home. So what do? They say if you take that $3,000 a month, move it to this new bank account, we'll pretend like you don't make more than $3,000, then more than the $2,800. So we'll pretend like you're under the income cap, and now you can get Medicaid benefits. And every month, the money that you put in that trust is either going to come out as a copay to the nursing home or potentially as payment back to your spouse. So in a lot of scenarios, we can have that income turn back over to the spouse if they need that money every month. And I'll talk a little bit more about that. But it goes in dirty and comes out clean. That's why I say money laundering, right? Wash it off every month and you stay eligible for that benefit. It's legal. It's what they require. You're not breaking any rules. It's just the important part about that is we have to have a special power in our powers of attorney in order to create that trust. So if you have an old power of attorney or an out-of-state power of attorney or a very basic power of attorney, or you worked with an attorney that wasn't an elder law attorney who worries about these things, you may not have that authority in your power of attorney, which can be very problematic down the line, because if you can't create that trust, you cannot get Medicaid. In order to get over that, we then might have to do a guardianship, which can run anywhere from $7,000 to $10,000 initially, plus sometimes a couple $1,000s a year, plus you're under court supervision during the time you're in a guardianship. It can be a very burdensome process to get that trust in place later if you don't have that power of attorney authority. Simple fix, especially if you're facing long-term care issues, if you've got the diagnosis or your loved one does, let's try to get that power of attorney updated as soon as possible so that you have those authorities in place when you need it. I'll talk more about the power of attorney in a little bit, but just know that that's your first caution is you have to have a good power of attorney to do this planning. And even though you may trust the lawyer that you saw, if they don't have a background in elder law, they may not have thought about this stuff. They don't know. I don't do any car accident injury stuff. I don't do any real estate, closings. My specialty is elder law, estate planning, long-term care planning. Unfortunately, a lot of people that aren't experts in estate planning think they can do it as part of their practice. And a lot of the stuff that I see come through our office is not good enough to take care of you, especially those folks who are in this group who likely already have someone with a diagnosis that needs to be taken care of. So plan early and try to get that taken care of. The other thing I like to just throw out there is that, even though you may not be sure if your loved one has capacity to sign new documents, know that that's they may, even if you think they may not. Because what we typically are looking for is what we call a moment of lucidity, which is, do they understand in the moment what we're asking them? Do they understand during that conversation what a power of attorney would do, what their assets are, who we're naming? And if they can understand that and agree, then often we can do a power of attorney, even if they may have some memory loss where they don't remember what they had for breakfast. So those two things are not mutually exclusive. So no, it's worth talking to an attorney to see if they think they can help you. Asset-wise, you've got a $2,000 asset limit for Medicaid for the applicant, and then a $154,000 allowance for the well spouse. So if you're a married couple, you can have $156,000 in assets and still qualify for Medicaid. That number also excludes IRAs. So no IRAs are counted in that number. That number also excludes the house. So your value of your house is on top of that. So it's not uncommon. We might have folks who have, over $1 million, sometimes over $2 million, sometimes more than that, where we can still get them Medicaid because of these generous allowances in Florida Medicaid and federal Medicaid rules. So never assume that you don't qualify for these benefits. it is a huge asset allowance. And above this, we can often protect up to 100% of the assets if you're married, about 80 to 100% of the assets if you're single. So long as we have the right authorities and the power of attorney to do this planning, in Florida, we're often able to protect 100% of the assets. So no, and we'll talk a little bit more about that just coming up. This is just going to explain again a little bit those medical requirements. As I mentioned, this is what we typically refer to as activities of daily living. These are the things Medicaid is going to be looking for you to need assistance with. Typically, what's not on there is medication management as a traditional activity of daily living. But again, when you're talking to the doctor, you want to explain everything that they need help with. So know that that's the traditional activities of daily living. We talked about this a little bit. And again, I can provide these slides to Diane for anyone who may want a copy of this presentation. I'm going to skip through a little bit of this because we talked about some of it already. But there is no limit for the applicant, for the well spouse's income. So we talked about the income cap and the qualified income trust for the applicant, but for the spouse who may be at home, that spouse could make $5,000, $10,000 a month and their loved one can still get Medicaid. Because Medicaid puts no cap on the income of the well spouse, that is a huge protection for the spouse here in Florida. And in addition to that, we often can use that income allowance when we're planning for assets as well, because by moving assets around and turning them into income sources, we can sometimes take the money above the $152,000 and protect it for the spouse as well. On this next two slides, I'm going to talk about the opposite situation, right? So on one hand, we can protect this money if the spouse has too much or has more income than the person in the nursing home. But let's talk about the scenario where the wife or husband makes $800 a month and the person in the nursing home made $4,000 a month. And they say, I can't put my husband in the nursing home because I can't afford to lose his income. Well, under Florida rules, we can sometimes turn over 100% of that income to the at-home spouse using one of two processes. This slide sort of explains that Medicaid allows you to have a $2,465 a month minimum income. So if you make $800 a month, you can bring your income up to this minimum income amount and still qualify for Medicaid. So whatever gets turned over to you reduces your spouse's copay at the nursing home. So that's one option. The second option is that we have available here in Florida is what we call spousal support. Now, this is not a Medicaid process. This is a Florida family law process. I like to refer to it as, alimony without the divorce, right? So what you say in this situation is, we've been married 10 years, 20 years, 50 years, and we've been pooling our income to pay for our house, to pay for our insurances, to pay for our car, pay for our dog, pay for my beauty salon, pay for my trips, whatever it is. And now all of a sudden, my husband's taking this money and turning it over to the nursing home, leaving me without care. We can potentially petition the court to get 100% of that income or 100% of the need covered from your spouse's income. So even if that number is $6,000 a month, if that's the quality of life that you've been living up to and before Medicaid, we can continue you in your traditional quality of life using that process. So it is quite possible for a lot of folks that their loved one will be in the nursing home for zero out-of-pocket costs. We can protect sometimes all of the assets and all of the income. So what that really means for families is you should be making this nursing home decision based on medical need and emotional needs, not financial decisions. Because for the most part, you will not go broke if your loved one needs nursing home care with proper planning. So see an elder law attorney, make sure you have the ability to do this by having a good power of attorney. But once those things are done, we can typically protect up to 100% of these benefits. Now, the things I'm talking about today are exclusive to Florida. I shouldn't say exclusive, are specific to Florida. Not every state is going to have these same criteria. So often if your kids come down and sweep you back up to the Northeast or out to Illinois or even the West Coast, a lot of those states are less generous. Almost all of the states are less generous than Florida in these benefits. So my common advice is to make sure that you talk to an elder law attorney here and an elder law attorney there before you make a decision about leaving Florida, because it can have a huge economic impact on what it costs you to get these care in other places. So you want to understand those rights and benefits by consulting with educated individuals about what coverage might be available. Any questions about the income protections? No. Okay, good. All right. Then we talked a little bit about this. The asset limits for Medicaid are going to be $2,000 for the applicant, $153,000 for the $54,000 for the spouse, up to 100% of the house. If the person is married, any income limit, any house limit is protected. If they're a single individual in 2024, you have your home equity up to $713,000 is protected. That used to not be a problem, but with the housing market going crazy, we see that creep in a little bit. But typically, Medicaid is going to use the property appraiser's valuation on that house, which is often lower than current market price. So know that that's another, consideration when you're doing it. One car doesn't count. Funeral plans don't count. You can have a $2,500 in a burial fund. Most of your household goods, they're not counting. And then whole life insurance up to $2,500 and any term or group life insurance. So if you have an employment benefit term policy or group policy, those don't count as well. So those don't count. Here is just that sort of chart explained in a different way. The top column is for the applicant, activities of daily living, either 28, 29 or less, or an qualified income trust and 2,000 less. Bottom is for the spouse, if there is one. They don't look at the health. There's no maximum income, although we can divert income for a low income spouse, and 154,140 or less of countable assets for the well spouse. If you're above that limit, if you have more than $154,000, which many of our clients do, you can pay down the money. You can pay for a funeral, buy a new car, fix up the protected house, pay off debts. So for a lot of people, if you're carrying a mortgage or credit card debt or your grandchildren's student loans, but your name is on them, there are things that people carry. Paying off any of your debts is a easy way to bring your assets lower so that you are closer to qualifying for Medicaid. Again, because the house is 100% protected, paying off that mortgage is often an easy tool to bring those assets down in a quick and efficient manner. What if you need other assets? I always like to say, I joke here, don't look to your book club for Medicaid planning advice, right? Because a lot of people hear a lot of things, right? Well, my girlfriend told me that she did this and that's how they got Medicaid. The rules change often. What works in one place doesn't work everywhere. Don't go telling people that live in Illinois what I told you, because they're going to be jealous because they can't do a lot of the things we are talking about today, right? So you really need specific advice for you and your specific circumstances. But one of the things that a lot of people hear about is the Medicaid look back, right? They hear, I know I can't give money away for a certain amount of time. Currently, the Medicaid look back period is 5 years, used to be 3 years. And Medicaid's looking for gifts you may have made that reduced your assets during that 5-year period to see if you had money, you gave away money you could have used for nursing home care. Now, there are exceptions to that. During, say, the housing bust a few years ago, we had a lot of folks that were giving money to kids, grandkids, to avoid foreclosures, to make sure their grandkids weren't homeless, that their kids lost their house and their grandkids were living on the street, right? So Medicaid is only looking at gifts that you made with the purpose of getting eligible for Medicaid. So if you have been giving to the church and then suddenly have a stroke, they're not going to penalize those gifts to the church. They're not going to penalize those gifts to the kids. But if they think you gave it away to get rid of money so you would be eligible for Medicaid, that's when the 5-year look back applies. Now, the other place in which the 5-year look back does not apply is they do not look at the gifts between spouses. So if one spouse has $500,000 and the other spouse has $1,000 and you move money between spouses, that's perfectly fine. There's no look back. There's no penalty. We can give away as much money between spouses as is necessary for planning. So just know that you don't have to worry about transferring money between spouses. What happens if you do transfer money during the look back period for planning purposes? Medicaid is going to impose a 1-month penalty for every $10,438 you give away. So in my example here, I use 18,000 because that's how much a lot of people, the IRS lets you give money away every year. And a lot of people know that number. It used to be 12,000, then it was 15, now 17, now it's 18. So you can give away $18,000 a year without an IRS issue. If you gave that $18,000 away to your child, Medicaid is still going to impose a penalty, right? Because they impose a penalty for every $10,438 you gave away. So for that $18,000 gift, you're not eligible for Medicaid for 1.72 months. So if you did that and you have 3 kids, so you gave $18,000 a year to 3 kids every year for 5 years, you are not going to be eligible for Medicaid for 15, 6, something like that. I'm just roughing that in my head, 12 to 15 months, let's say, which means you have to privately pay for the nursing home during that period. So if you have a diagnosis, if you are concerned about upcoming care, be very cautious about giving money away because it could come back to bite you. If your child is telling you to give them the $18,000 a year because it's allowed under the IRS rules, know that right now, most people don't need to worry about those IRS rules because you can give away an unlimited amount of money under the IRS, not an unlimited amount. You can give away almost $13 million during your lifetime without ever incurring an IRS gift tax bill. So the first 13 million a piece that you leave to your family is not taxed. If you're married, that number is closer to 26 million. So that's not most people. If you have anywhere in the 13 to 26 million, we're not going to be having a conversation about Medicaid in all likelihood. So you can give it away. But short of that, you can tell your kids, I've got to find out whether I can give you that money before you write that check. Okay. You don't want to be, you can tell them I told you, you can't give it away. So just be cautious about that. I'm going to skip that. So there are strategies that we can use to deal with excess assets. Gifting ahead of time, so before the 5-year look back, is an option. Sometimes we explore. In Florida, we have the ability to do income producing property, which is a huge benefit. Medicaid, among those assets, Medicaid does not count the value of rental property. So if you own a second property that you rent, Medicaid does not count the value of that property. They do count the income potentially, but not the asset. So as a planning strategy, sometimes you might buy an interest or a whole piece of rental property. If I put $100,000 into a rental home, that $100,000 is now not countable for Medicaid. And that can be a huge planning opportunity for us when looking ahead. It is important if we do that to have a special kind of deed on that property called the Ladybird deed. I'm not going to go into a lot of detail about what that is right now, but I would say is if we're going to use income producing property, be sure you're talking to a lawyer about having a Ladybird deed on that property. And under current law, that will mean that Medicaid will not be able to come after that money even after your death. So proper planning is required to protect that not only during your lifetime, but also after death. So just know that you need to be planning ahead for that. So, and then what we really need to be doing, well, the takeaway from the Medicaid and all this conversation is with proper planning, we can protect usually up to 100% of the income and up to 100% of the assets. And you should not assume that you don't qualify, even if your assets are higher than you think they should be. It is not uncommon for folks with over $1 million to still become eligible for Medicaid, depending on how we structure that, and so long as we structure it properly. The other thing I like to tell people is everything we do is legal. Everything we do is disclosed to Medicaid. There are no secrets in our planning, right? I'm sure you're all nice people, but I won't go to jail for you. So in order to qualify for Medicaid, we're going to do everything above board and disclose it. We won't participate in any fraud or crimes. So all the stuff I talked about here, all these protections are available to you. Medicaid knows we use them and they are permissible. So you don't want to leave these planning options on the table. So what should you be doing now to protect yourself going forward? Well, any questions about any of that? No? Okay. So what should you be doing now to protect yourself going forward? First is the durable power of attorney. To me, this is the most important document in your estate planning portfolio. It is the only document that is not permissible. There is not a statutory assumption that someone else can do this job for you. So I'm going to talk a little bit about the will. I'm going to talk a little bit about healthcare directives. Those things, the law makes assumptions. If you don't do a will, the law will tell you who gets your money. If you don't have a healthcare directive, the law will tell you who can make medical decisions for you. If you don't have a power of attorney, no one is able to make these decisions for you, even your spouse, unless they go and get a guardianship, which is that expensive court process we talked about earlier. So this becomes really the most important piece in your plan. A power of attorney, our power of attorney is almost 20 pages of legalese and fine print. And I like to warn people about that, right? That you're going to get it. And I might hear you scream out my name from home because you're mad that we would shove all that stuff in there. But under Florida rules, effective 2011, when the Florida legislature changed the power of attorney statutes, you have to be very explicit in a power of attorney in order for your agent to have the authority they need. All of this long-term care planning authority requires special grants of authority, and it includes that those things must be initialed. So a lot of times what happens is attorneys who don't do this kind of work might have a power of attorney that has this language in it, but if they don't have you initial it, it's not valid and we can't use it. So you want to make sure that your power of attorney is evaluated, reviewed, and up to date so that we're sure you have all the authorities that you need. In Florida, when you sign a power of attorney, it is immediately effective. So you're going to sign this. The next day, your spouse or your kids might be able to go out and use it and act for you at the bank with your insurance companies, with your things. And that scares people because they say, well, I'm not ready for someone to be out there using it. But under Florida law, you cannot have what we call delayed power of attorney. You can no longer, they got rid of that in 2011. You can no longer say, this only comes into play when I'm incompetent. So my advice to folks is you go ahead and you sign it. And if you're not ready for your children to be using it, simply don't provide them a copy right now, right? Without a copy, they can't use it. So you can sign it, put it in a lockbox in your house, tell them you did it. If let's say we were your attorney, we might say, give them our business card. We'll have a copy of it. And then they have ways to get to it if they need it, but they're not out using it before you're ready for them to use it. The other thing that I like to say is, you want to give some thought before you have your conversation with your lawyer about who's the right person to do this job. This job is all financial and legal decisions. So you want to make sure that you've got people who are going to make the decisions you would make financially and legally, that are trustworthy. You can name agents generally in one of three ways. In order, so my wife, then my daughter, then my son. You can name them jointly. So in my case, I might say my wife first, then my daughter and my son having to work together. Or you can name them joint and severally, which means I don't care if it's my wife, my son, or my daughter. Any one of them can act when I have a need. So, or when they want to act. There's no chief in that situation, which can be problematic. If your family doesn't get along, I wouldn't advise that. But so long as everyone gets along, joint and several is also a good option. And then you want to make sure that they're trustworthy. You are giving them the keys to the kingdom, right? They will have access to your banking, to your investments, to your insurances. And if you are not trusting them 100%, I don't care what the relationship to you is. If it is your spouse, if it is your kids, if they are not trustworthy, you do not give them the keys to the vault, right? And so, a lot of times that means us having a conversation about, is there someone better suited than your family? When it comes to all of this planning, we don't worry about hurt feelings. We don't name someone we wouldn't want to name simply to avoid them, having hurt feelings. Any questions about the power of attorney? No? Oh, I can't hear you, Gabriel.
Can you hear me?
I can't make out what you're saying. Try again. You're talking, but I can't.
Can you hear me?
A little bit.
Okay, I just want to know the spouse and then the old spouse, or do you need to name somebody else outside of the couple?
Okay. So what I heard was, do you have to name your spouse, or you can name someone outside of your spouse as power of attorney? Is that right? Is that what you asked?
Yeah.
Okay, good. So yes, you don't have any obligation to name your spouse as the power of attorney. You can name anyone you want to do that job. So for a lot of our clients, let's say someone does have dementia or Parkinson's, we're not going to name that spouse as the primary power of attorney, because it's very likely that that person isn't going to be able to go out, even if they're mentally capable. Sometimes they can't go out and drive to the bank to deal with things. They can't sometimes dial the phone or get on the phone and answer insurance questions or do any of that stuff. So often, if we're not naming the spouse as your first person. Now, many people still choose to, and that's okay. If your spouse, let's talk about my Parkinson's patients, right? Sometimes they may have difficulty communicating, even though they're mentally competent. So they want that spouse in as a decision maker, but recognizing that that spouse may have trouble communicating those decisions outside of the family. So they then name a child jointly and severally with them so that that person can step in and do the phone calls and the bank runs and the other issues. Okay. Does that answer your question? Okay. Thank you. And that raises another point, which is, do I think that if the people need to be local? And the reality is no. For the most part, in today's climate, your child from New Jersey or Iowa or California can do just about everything online and long distance that they can do here locally. So for the most part, so long as they have some accessibility, because sometimes you just need to come and take care of stuff in person. If they, so that's where I would say maybe not if they're overseas, right? If you're in Germany instead of California, you don't have access to American notaries. You don't have access to sometimes, the same services. So overseas can be difficult, but anywhere in the country is typically fine. Any other questions about the power of attorney?
John, I have a question if you could address. I get asked often about, or people will comment to me that they've taken care of their power of attorney in another state and now they're
Yes.
residing in Florida. Can you speak to that a little bit?
Yes, typically I'm going to recommend, if it's an out-of-state document, that you redo that if Florida is permanently home. Because as I was talking about earlier, say for that qualified income trust, out of state, if you come from a state that doesn't require qualified income trusts, that authority may not be in your power of attorney. If you come from a state that doesn't have the same strict rules that we have here for long-term care planning, a lot of those authorities often do not appear in powers of attorney from out of state. So our typical recommendation is, if Florida is home, get a Florida power of attorney. They're not inherently invalid, so I don't want to mislead anyone into thinking it's not valid. It just may be like, it's a key, but it's a key that doesn't unlock some of the doors that we need unlocked. And so it'll be only good for some things and not others. So yes, I would say if you're moved here and this is going to be home, get that document updated. All right. Is that good, Diane? All right. Thank you. All right. And again, anyone who has questions, just stop me at any time. So next would be the healthcare directives. The healthcare directives are broken down really into two, maybe three things. I mentioned two here. The first is what we call an advanced directive for healthcare. And that is the document that allows someone to make medical decisions for you. And I like to say 99% of medical decisions are made under an advanced directive for healthcare. Talking to doctors, getting medical records, consenting to surgery, treatment, rehabilitation, all of this sort of day-to-day medical decisions that need to be made are typically made under what we call an advanced directive for healthcare. That next medical decisions are decided under what's commonly referred to as the living will. And that is your end of life choices. So if you remember the Terry Schiavo case from now 20 years ago, that is a case where she didn't have a living will. So nothing to express her particular desires about end of life treatment. Our living will at our practice is a little different than you might see other places. Ours is generally broken down, again, the living will, into two pieces. One says medical doctors are deciding whether or not you qualify for a living will. So do you meet Florida's legal criteria to have life support terminated? Once the doctors say yes, then the timing decision falls to your family. Do you get a day, a week, a month, or no care at all? Will be things decided by the people you've chosen to make that decision based on what they know about your wishes, what they know about you, your condition, and your prognosis. And so we make it very clear that it is your selected individuals who are deciding how much care you get, not the doctors. That may differ from what some of you may have if you have a living will, which says, I do not want to be kept alive on life support. Sometimes that's written as a period, right? I do not want to be kept alive on life support. So if I need life support, pull the plug now. And if you need someone to talk to about pulling the plug, talk to Steve, right? Ours is written differently to say, I trust my wife to get me as much care as is appropriate or as little care as is appropriate. We've talked on many occasions about my personal desires. And so I want her to be the ultimate decision maker about when and what level of care I get. Our document is also a little broader to define end of life choices, to say not only does our living will cover artificial heart, lung, nutrition, hydration, dialysis, the typical life support, but if I have advanced dementia, for example, and my quality of life is very low, and I develop pneumonia, I've authorized my wife not to treat that pneumonia, right? To me, in that circumstance, that's life support. Without treatment, I will die. And I would prefer not to have an extra day of no quality of life. So you want to make sure that your living will adequately reflects your personal wishes, or at the very least properly empowers the people you've chosen to make those decisions in your absence. Again, same choices in this document as we had in the power of attorney. You can name them in order, so A, then B, then C. You can name them jointly, A and B working together, or you can name them jointly and severally, meaning any of the above. So you have the same options to decide who does that. Again, if you don't do this documents, then Florida is going to grant that to some specific folks in order. Primarily what we look at there. Oh, sorry. Yeah. Gabriel, did you have a question? Sorry.
I was ready for you to have questions. You have a question.
Okay.
Is there a link direct and the
I'm not hearing. Is anyone else hearing Gabriel clearly? Sorry.
It's not coming through very clearly. If you want to send a message in the chat box, I could read it to John.
Oh, yeah.
Okay. Sorry about that, Gabriel. You had some feedback there or something. while you type that,
While
I'll
you
just,
type that, I'll
I'll
just-
explain that, you want to make sure it adequately reflects your wishes. The one thing that is not included on this list is what's commonly referred to as a DNR, or do not resuscitate order. And how a DNR differs from a living will is that it is a medical prescription done by your doctor, not a sort of legal document prepared by your lawyer. And the DNR says, in very general terms, what the living will says, let me start with that. The legal document says, if you get me to the hospital and I'm not going to get better, don't do anything extraordinary to keep me alive. The DNR says, in some respects, don't bother taking me to the hospital, right? I don't want CPR. I don't want intervention. If I collapse of a heart attack right now, let me pass. Whereas the living will says, if I have a heart attack, get me to the hospital, get me whatever treatment I need. I might be fine tomorrow. Then do it. But if then I have I'm brain dead, let me pass. The DNR is much more extreme to say, don't intervene under those circumstances. So a lot of folks come to me with a DNR who are otherwise healthy, and I try to explain that difference. And they say, well, I didn't want that, which is scary because that means the doctor signed it, saying you did. But you want to make sure you don't have a DNR until the time is right. If you had a heart attack and do not want to be brought back, a DNR would be appropriate. Short of that, a living will is the appropriate document to cover you in most circumstances. Okay. I'll take a minute. I don't know if Gabriel's question is up yet.
Yes, so she's asking, is the advance directive for healthcare and the living will one document, or are they two separate documents?
Okay, so in our version, we combine them into a single document with two parts. So part A is the advance directive for healthcare. Part 2 is the living will. In some practices, they're going to be separate documents. So you might have an advance directive and a separate living will. In our experience, most people name the same people to make both those decisions, although we can do that as well if they don't want to do that. With the way we look at it is you sort of end up with 3 packets from our office for the most part, which is the power of attorney for finances and legal decisions, the healthcare decisions, which is the healthcare directive and living will in a packet, and the after death document, which is most commonly a will. So you sort of have those in packets. And but no, you might find it's either combined or separate. But if it's combined, it should say living will on it.
She's also asking if you need an attorney for these. She knows for the POA you do, but for the surrogate, can you do your own online?
You can. There are some versions online that would be reliable. The hospital will often give them to you if you're checking in and you say you don't have them. The only word of caution there is that some of the things I talked about, some of the more broader authorities that we're granting in our document are not the way that the basic ones read from the hospital or from the internet. So know that you may be less protected than we talked about today under some of those more basic versions of this. But yes, for the most part, you can get them online. If most people who come to do the power of attorney with us, we would also include a healthcare directive with that so that it's got all of those protections in place. But no, you may have one already that you got last time you went to the hospital and they said, here, fill this out. And so there are versions out there you could use. Yeah, there's also something out there called 5 Wishes that you may see sometimes that's like a living will or is a living will version. We don't use that anymore, or we used to have our own version of that. Ours no longer says if then statements. So in a lot of them, it'll say, if I am in a coma, then do this. If I can't recognize my family, do that. We got rid of most of those because we found it was providing more confusion than clarity, both for your family about what you want and for for the hospitals and doctors. And so our general document now just names someone to make those decisions for you, based on everything they know about you at the time. Comfortable with that? Diane? I see you got
Yes.
it.
And
Yeah.
there's another question that came in as
Oh,
well.
Great.
They had their wills and everything done in New Jersey prior to being diagnosed and prior to moving to Florida. So their question is, if they do new forms here, do they need to pull the New Jersey forms from the attorney's office, or will this one just replace the old one?
This one just replaces the old one. So typically speaking, when you do a new will, a new power of attorney or healthcare directive, it revokes the prior versions that you did. Now you can still let that lawyer know that you revoked them, so that they can destroy them. But for the most part, doing new ones will automatically revoke the old ones. And then, and I'll be happy to take more questions on that. I'm going to go to the next slide, but if anyone has a question, just chime in. Okay. Next document would be the last will and testament. This document is a direction to the court. Best way to describe a will is a direction to the court about what happens to your money after you're gone. And I'm going to talk next about trust. So I'll just explain a little bit about the difference between a will and a trust. A will requires probate to be effective. So you basically, when you write a will, you're basically saying, dear judge, this is what I want to have done with my money. This is who I want to appoint to take care of that for me. Would you please appoint this person to be authorized to handle my affairs, give my money according to this document? And then when they're all done, they're going to report back to you that they did everything they were supposed to do. And then they get discharged and you're fine. Comparing that to a trust is a letter to an individual who is not a judge that says basically the same thing. I trust you, hence the name trust, right? I trust you to do this without court supervision, without having to report to the court, and without any accountability to the court for your actions. There are pros and cons of that, obviously. A will probated in Florida generally is going to be completed within a year as a general rule. Once it's probated, the court generally gives up to 1 year to get everything done. If you can't get everything done in a year, then they're going to be asking why you didn't get it done, right? And so you would then are accountable to the court to make sure your kids or your spouse or whomever, your charities, get everything that they're supposed to get. In a trust, if that person doesn't do the job, there may be no one holding them accountable. The only police of a trust are the beneficiaries. So assuming those beneficiaries know that they're supposed to get this money, they then will have to follow up with the trustee to make sure the trustee is doing their job. I like to say that for many of my clients, we are not recommending trusts. Now, you can go to a lot of free lunches in Sarasota and be told that everyone needs a trust, right? You each probably get at least one note card a week that says, come to a free lunch, your steak is reserved, and we'll tell you why you need to buy a trust from us. I find that that's not often true. One, a lot of people are dealing with their estate using beneficiary designations, right? So on your bank accounts, on your IRAs, on your life insurance policies, a lot of people have already named their beneficiaries on those accounts. So a trust is not going to provide a lot of after-death benefit for those folks. The other thing is, so many clients have trusts from before they come to see us that they never funded, right? So the way I like to describe a trust to my clients is a trust is a robot you build separate from yourself. It is not you, it is a separate entity, like a corporation would be. And unless you give money to the trust doesn't own it and it doesn't control it. So if you die with assets not in a trust, then you have to first probate them, where they will get moved to the trust, and then they have to be administered as a trust. So an improperly funded trust is actually twice the work of having either just a will or a properly funded trust. So the worst case for me is someone who has a trust and doesn't fund it right, and then we have to go through all the process of probate only to move it to the trust and then do a full trust administration to get it out of that trust. So know that a lot of folks don't do it right. And so for that reason, sometimes we're not recommending a trust for them. There are other tricky things here in Florida when it comes to final planning. One of the big ones is our house. The other one is the elective share. And with our house, there are some restrictions on who we can give that property to without a prenuptial agreement. If we don't have a prenuptial agreement, our spouse is entitled to an interest in our house, no matter what. So if this is a second, third, or fourth marriage, which we see a lot here in Sarasota, and you had a house before you got married without a prenup or postnup, and you say, well, I'm leaving this house to my kids, and your husband's fine with that, know that when you die, your spouse may claim a share in that house under the law, no matter what you did. They can have either a life estate in the house, meaning they can live there forever, or until they die, or they can have a 50% share of the house and claim 50% of it. So know that especially if you were not married when you bought the house or when you did your last estate planning, know that marriage can affect how you can leave your house. The other thing that we have to be conscious of with the house, and it doesn't happen for a lot of our clients since we do elder law, is if you have minor children, you cannot disinherit minor children from the house. You cannot give the house to anyone but your family if you have a minor child living with you or at all, really. So house, particularly tricky issue. If the house isn't going to your house, make sure you talk to your lawyer about that. The other is what we call the elective share, which means that if you got married, your spouse is entitled to essentially a 1/3 interest in all other property. So if you have $1 million, and you choose to leave that all to your kids, and he has $1 million, he's leaving it all to his kids, know that after your death, without a pre or postnup, they can claim 1/3 of that money, even if your will says otherwise. So know that, again, not every state has an elective share. So you may be coming with wills from out of state or be coming from a situation that doesn't account for that. Know that you need to be thinking about that in Florida if you left a will behind and have a sort of alternative distribution plan from your spouse. Any questions about the will so far? No? Okay. And I think that lastly is a trust. As I mentioned, I don't recommend a trust for everyone. If I don't think you'll end up funding it properly, or, a lot of people think it avoids probate and therefore avoids a lot of cost. The reality is the statutory trust administration rates for the first $1 million is 2.25%. The statutory administration rate for a will is 3%. So if you're using statutory fees, you're only talking about a difference of 0.75% difference between a will and a trust. So it is not a huge cost savings often between a trust administration and a will administration. That's one issue. The other is, as we mentioned, there may not be court supervision, which you may want under certain circumstances. And then the other is the times we might recommend a trust for someone is if they have property in more than one state, real property. So if I own a house here and a house in Michigan, I'm going to probably want a trust to hold at least that Michigan house so that I don't end up having to probate multiple times, right? Because if I have a house here and a house there, I would have to probate here in Florida, but then I would also have to probate in Michigan to get the house taken care of. So you can start making it more burdensome if you own property in other places, especially if you have timeshares or oil wells, right? Some people have oil wells in Texas and an oil well in Oklahoma and a timeshare in Nevada. And if you die without that being in a trust, you are going to have to probate in each one of those states to get those assets. And so there are times when trusts are absolutely perfect or appropriate. The other time is if you have a complicated kids situation or family situation where the kids don't get along and you really want to empower someone and keep it out of court to avoid lawsuits. A trust is appropriate, but just know that it's on a case-by-case basis. If someone's telling you everyone should have a trust, I would disagree with that perspective. And actually my wife and I, she's the other Griffin at Griffin and Griffin. We're both estate planning elder law attorneys, and we don't have a trust, right? We've got a minor child. We used to have two till Monday. And so we have two kids, one of whom is a minor. I don't care. I don't mind that there's some court supervision over the administration of our estate to make sure our kids are well protected and taken care of. The probate process in Florida is not that burdensome in the long run. And so just know that you really need to understand why you need a trust, not just that everyone needs one. The one thing I didn't mention here when we talk about the last will and testament is there is, for those of you on the call or listening to this recorded who have a spouse that may have Parkinson's or another long-term care disability, know that there's a special type of will in Florida called an asset protection planning will that elder law attorneys can do for you that will potentially protect your resources if the well spouse dies first. So if you have an ill spouse who's at home, let's say, but if you died, that spouse would need to go into care, we want to plan appropriately so that the assets are in the name of the well spouse potentially, go into a protected trust for the ill spouse so that all of those assets end up protected from Medicaid and that spouse can get benefits right away. It's called the Special Needs Trust. You want to make sure that you're doing that if you're in a scenario where your loved one would need care in your absence. Some people do it well in advance, but certainly once you have that diagnosis, you want to be thinking about that, planning and talking about that type of will with an appropriate elder law attorney. Any questions about that type of will? No, looks okay. All right, so I think we'll go into the, just final questions here, Diana. I know we're probably running low on time, but I've got time to take questions if you do.
Does anybody else have anything that they would like to ask John at this time? You can unmute yourself or you can send a message in the chat box.
No. Well, I will say then we offer a free consultation, initial consultation, so that if you have specific questions to your circumstance, you can meet with me. We do Zoom, we do telephone calls, and we do in person. So we can meet with you and your loved ones. The idea there is you shouldn't have to pay just to hear if we can help you. So come in, you bring your documents, we'll review what you have or send them in advance and we'll look at them. And we can answer any questions to your specific circumstance. Our office is on 41, just south of Clark Road. So just past the Fin and Tonic, used to be Red Lobster, and just north of what used to be Outback, and is now that's closed. All the chains are going out of business, but yeah, we're right there on 41, and we'd be happy to answer and see anyone who needs these questions answered.
Thank you so much. Some comments coming in thanking you for all the great information. So we very much appreciate your time, and thanks everybody who was able to join us today. And we'll get the recording up, and John, if you want to send me the slides, that'd be fantastic. So
I will do that.
Thank you so much, all. Have a great rest of your day.
Thanks, John.
Thank you. And sorry about that little hiccup in the middle.
No problem.
All right.
Thanks much.
Thank you.
Bye-bye.